Welcome to the Evelyn Y. Davis studios at the National Press Foundation. Coming up, we'll talk with an expert about what journalists need to know on covering the Supreme Court. It's right now. The National Press Foundation is a nonprofit dedicated to helping journalists cover complex topics with depth and accuracy. Our mission includes journalists around the U.S. and around the world. I'm Linda Topping-Streitfeld, Director of Programs at the National Press Foundation. With me today, Amy Howe, reporter and editor at SCOTUSblog, a go-to website for lawyers and journalists and just about anyone who needs to know what's happening at the court. Amy, welcome.
Thanks for having me. It's good to be here.
If you're watching live, you can type questions into the chat window under the webinar box. You can log in or simply sign in as a guest. We'll answer as many as we can. Amy, we just have 30 minutes, and I want to very quickly get to your information. But first, please tell us in a nutshell what SCOTUSblog has to offer.
SCOTUSblog is a website devoted exclusively to the U.S. Supreme Court. And so we cover all of the major stories at the court, nominations, oral arguments, major decisions. But we also serve as sort of a clearinghouse of information on all of the cases that are argued at the court on the merits, and many of the cases that the court is considering whether or not to review them on the merits. So you can log on and find all of the briefs that have been filed in specific cases, for example.
Perfect. So I know we've sort of broken your presentation down into 5 things that journalists need to know. What's number 1?
The first one, and I think it's really the most important one, and we're probably going to spend most of our time talking about it, is that it's really important to understand how the Supreme Court works, know the process. The Supreme Court is a perhaps more mysterious place than many of the institutions around Washington that most journalists cover. But once you understand some of the basic nuts and bolts, it's pretty easy to follow what's going on. And although in some ways the Supreme Court is not a particularly accessible place, they don't televise their oral arguments live. They don't televise the announcements of their opinions live. In some ways, it's very accessible for journalists because everything essentially happens out in the open. Everyone has access to many of the same proceedings. And so the first thing to understand is sort of where the court's caseload comes from. The Supreme Court every year, according to the Supreme Court itself, has roughly around 10,000 requests to review a case on the merits. The Supreme Court has near total control over what cases it decides to decide, in essence. There's a very tiny percentage of cases that it's obligated to decide. Many of those involve water and are not likely to be on the front page of the New York Times or the Washington Post. But we're going to focus on the ones where the Supreme Court has some discretion. You will hear that the Supreme Court, they will actually hear oral arguments on the merits in roughly 75 to 80 cases each year. It's actually down from about 150 during the 1980s. And so if you look at 10,000 requests to weigh in on the one hand and 75 to 80 cases that they hear on the merits, it seems like a relatively small number. Your chances of getting review are somewhat like getting hit by lightning. But I think that's a little bit exaggerated in the sense that many of those 10,000 requests actually come from prisoners who are filing, asking the Supreme Court to address their grievances with prisons. They are able to file, usually if they're in prison, without cost, and they have a lot of time on their hands. So many of the cases come to the Supreme Court with basically 0.0 chances of getting granted. It's some grievance with the prison. You can have some that are not necessarily filed by prisoners, but along the lines of the CIA has implanted a chip in my brain and I want you to order them to take it out. So I would say there's actually probably around 250 cases every year that have a shot at getting granted. The Supreme Court has a number of criteria that they look for when they're deciding whether or not to take a case. The first one, and one of the very important ones, is whether or not the lower courts of appeals have reached different results on the same legal question. And so in the days leading up to the court's announcement back in October that it wasn't going to hear several cases asking it to weigh in on same-sex marriage, one of the things that Justice Ruth Bader Ginsburg mentioned was, there's no division among the lower courts of appeals. There was not at that time. All of the lower courts of appeals that had considered challenges to state bans on same-sex marriage had struck down those state bans. And it wasn't until January, just last month, when the court had a request from couples in 4 states, Kentucky, Michigan, Tennessee, and Ohio, to review a decision by a federal court of appeals upholding those states' bans, that the Supreme Court actually decided to step in and grant review. So the first step is whether or not there's a division among the lower courts of appeals. The second is whether or not you've got 4 justices, because 4 justices need to vote to grant review, who think that the issue is an important one, that it's worthy of the Supreme Court's time. And then the third question, and it's a little bit of an esoteric one, is whether or not this case is essentially what lawyers call a good vehicle, a good opportunity to review the question that the Supreme Court's being asked to take up. Because the facts are good, because this question would decide that particular case. There's no sort of tangential question that might cause the case to spin off in another direction, and in essence to be a waste of the court's time. If you're only going to hear 75 or 80 cases each year, you want them to be, in essence, good ones. You want to be able to grant review and then see them all the way through the process. Right. So you can file what's known as a petition for certiorari. That's a request for the Supreme Court to weigh in. The other side has the opportunity to file a brief, usually opposing review. It's called a brief in opposition, telling the Supreme Court why this case does not warrant its time. And then the case goes to what's the Justices' Conference, and that is a private meeting of the 9 justices. It is only them, and there's none of their law clerks, none of the staff from the court. And they have before them a list of cases in which people have asked them to weigh in, and they go around the table and they vote. And a case needs at least four votes, as I've said, to grant review. If not, it's denied. And this, in the last year or so, the Supreme Court has usually what's happened is that they have their private conference, and then either that day or usually sometimes the following week, the Supreme Court will release what's known as an orders list. It says, in essence, we're granting this case, we're denying review in these cases. And recently, the Supreme Court has developed a practice of only granting review in a case after it has considered it at least 2 conferences. There's never been an official announcement about why the Supreme Court is doing this, but the feeling among lawyers and reporters who cover the court on a regular basis is that the Supreme Court then uses that extra week to make sure that this is actually a case that it really wants to take. It does some due diligence to make sure that if it grants review, there's not going to be some question that causes the case to go away either before oral argument or after everyone has invested the time and the resources to brief and argue the case. And so if you're covering the court and a case that you're following is on a conference, one of the things you want to know right now is whether or not it's on that conference for the first time, because after that conference, the court could well grant review, but it probably is not going to do so for another week.
Can I ask you, those conferences are only the justices?
They're only the justices.
Is there a recording made? Is there a transcript? Do we ever learn?
No, there's not until, as with so many things with the justices, you don't really have any sense of what goes on in these conferences, sometimes ever, but usually not until a justice releases his or her papers, which, in the journalist perspective, it basically might as well be that it's more a matter for the historians.
Right, when there's no news value whatsoever, then you can know it.
I mean, occasionally, it's not very often, but occasionally the court will decide to deny review in a particular case, and one or more justices may decide to write either a dissent from that decision, which becomes public, and they explain the reasons why that justice thinks review is worthy, or also even what's known as a statement respecting the denial of review, which Justice Stevens, for example, did one during the George W. Bush administration in a challenge to President Bush's recess appointments. And this is the question that was resolved last year by the Supreme Court, That was a challenge to President Obama's recess appointments, but this had been a challenge to one of President Bush's recess appointments to the federal bench. And Justice Stevens wrote a statement respecting the denial that basically said, we're not going to review this question right now, but we trust that this is not something that the administration is going to do very often. In essence, sort of a warning shot
Caution.
Across the bow. And there were not many more recess appointments after that. Yeah, so you get an announcement that the case has been granted or denied. If the case has been granted, that then kicks off a briefing process. And so this is something that the Supreme Court has on its website and that we have on our website at SCOTUSblog. All of those briefs are a matter of public record. You could go to the Supreme Court and actually look at the hard copies, but they're also available online. And so the parties themselves each get another chance to file briefs. The first time around, the briefs were focused primarily on why this was a case that the court should review.
Right.
And then the second time around, the merits, it's exactly what it says. This is your chance to argue in roughly 50 pages or less why you're right and the other side is wrong. So each side gets the chance to file briefs. They also have what's known as friend of the court briefs. I say amicus briefs. There's a debate about how you pronounce that. Justice Breyer says amicus. Others say amicus, A-M-I-C-U-S, however you want to pronounce it. And these are friend of the court briefs. They are written by parties who want to present usually a different viewpoint to the court or to explain why this case is important to people beyond the parties who are there. And so, for example, in the healthcare case, King versus Burwell, the challenge to the availability of subsidies under the Affordable Care Act, you've got briefs from the healthcare industry, you've got briefs from insurance companies about what this decision, one way or the other, could do to us. And then you have briefs from law professors. Law professors love to write briefs, and scholars. This is what from Congress. This is what we intended when we actually passed the Affordable Care Act. So those briefs come in. The briefing process usually takes, roughly 2.5 or 3 months, and then the case is set for oral argument. Going into the oral argument, this is an opportunity. It's usually an hour for each oral argument. Sometimes the court can, as it's doing with the Affordable Care Act and this is same-sex marriage, likely to extend that because it thinks that the questions presented need more airing. And so this is a what's known as a hot bench at the Supreme Court. There are a lot of questions, usually for lawyers on both sides. They get up, they say, Mr. Chief Justice, and may it please the court. And usually, if they're lucky, they get out a couple of sentences before they get the first question from one of the justices. The briefs are extensive. And you don't want to, they're not usually going to be presenting anything new at oral argument. This is their chance to address the justices' concerns about, what is the scope of their position? If we rule in your favor, what is this going to mean for all of the other cases that are similar and maybe aren't even quite that similar? Because when you only take 75 or 80 cases per year, you want your decision to apply to more than just the case that's before you. So they're asking the lawyers questions, but they're also talking to each other. And so this is something that's very important to know when you're covering the oral argument. And sometimes you can actually see it at oral argument. Sometimes Justice Breyer will ask a question and he'll look down the bench to make sure that his colleagues heard his question. Because one of the things that people find somewhat surprising about the Supreme Court is that at the point that they grant review in a case, they often don't talk to their colleagues about this case until the oral argument and then when they vote on the case after. So this is their chance to talk to each other. And when they go into the conference after the oral argument, they go around the table in order of seniority and vote. They start with the Chief Justice, then they move on to Justices Kennedy and Scalia. I can never remember who came first, Justice Ginsburg, around the table, and then Justice Elena Kagan. And so I've heard speeches where she said by the time she gets to vote, often the case has been decided. And so oral argument is their chance to talk to each other and to try to influence each other's votes before they actually get to the conference. There is a website called SCOTUS Now. It's the Illinois SCOTUS now, and there's a law professor there who, after every oral argument, goes through and tracks the number of questions for each side as a rough predictor of who might win the oral argument. And it's not a perfect predictor, because there are sometimes cases in which the justices, may have made up their minds. It's not something that they care a lot about, and may just stop asking questions for one side or the other and let the advocate talk. But it's often a rough predictor of how each side is going to fare. After the oral argument, particularly in high-profile cases, the lawyers and the parties may gather outside on the Marble Plaza at the Supreme Court to make statements about the oral arguments and answer questions from reporters. So that's an excellent opportunity to talk to some of the folks who are involved in the case. The lawyers from the federal government who are involved in many of the high-profile cases at the court don't go out there and won't speak publicly, but in high-profile cases you can often find almost everyone else out there on the plaza answering questions and talking about the oral argument.
I'm going to stop you for 1 minute because this is a good segue to a question coming in from a viewer who wants to know, if you are outside of Washington and trying to cover a case remotely, where can you go to get information about how to follow the case?
Sure.
Now, this could be something that we are going to get to.
We are going to get to some of it. We are going to get to some of it. I'm going to talk a little bit more about the process and then segue into that in the next step.
So stay tuned. That answer is coming.
Yes. So after the oral argument, sometimes the same day, sometimes a day or two later, the justices go back to their conference room, and it's just like the conference where they decide whether or not they're going to review particular cases. They vote on the cases in which they've just heard oral arguments. And as I said, they go around the table, the 9 of them, and it's completely private, no law clerks, no staff. And then if there is a split decision, a majority, what we call a majority and a dissent, the senior justice in the majority gets to choose who will draft that opinion. The senior justice in the dissent gets to assign that opinion, and so
they can assign it to themselves.
They can assign it to themselves, certainly, and they do. The Supreme Court does a very good job of trying to assign opinions evenly, so that everyone has roughly the same number over not only over the course of the year, but over the course of a month when they hear oral arguments, so that your Justice Breyer is not writing 5 opinions from December or something like that, but they do it. They assign the opinions and then they start writing. And how long it's going to take to get an opinion in that case just depends on how many opinions there are, how complicated it is, and so a 9-0 opinion can come out in 2 or 3 weeks, particularly at the beginning of the year. You can have a 5-4 decision that from a case that was argued in October or November not come out until the end of June. You don't know. And so when the drafting process, and this is all done very privately, no leaks from the court into the rest of the world.
Even though you have to assume clerks are doing a lot of that drafting.
Yes, and
the clerks are very
the clerks are also very close-mouthed. The clerk is the least likely person you're going to get any good information out. I mean, they frequently don't even want to be seen talking to a reporter in the cafeteria, so they're not going to be your inside source at the court. But if whoever just drafts the majority decision then sends it out to all of the other justices, and they have an opportunity to suggest changes or say, okay, that looks good to me, I'm signing off on it. And then the same process can happen with the dissent. And sometimes there can be a back and forth as the opinions, and this takes a while. This is why they take a while, as the opinions get changed to reflect the other's positions. Unless it is the last, and eventually an opinion is ready, unless it's the last day of the Supreme Court's term, we never know on any particular day either how many decisions we're going to get or what ones we might get. And so you kind of have to be ready for anything. You can check on the Supreme Court's website if you are covering specific opinions to see whether and when they're going to be issuing opinions, and certainly. But
you don't know if that's going to be the one you're interested in.
Exactly. I mean, you can certainly guess that the opinion in the same-sex marriage case is probably going to go until the end of June, but you just never know how these things are going to go. And so what happens is that the justices come in and they sit down and they said the Chief Justice will say, Justice Breyer has the opinion in number such and such, the recess appointments case, and then he announces his decision. Some reporters like to be in the courtroom to see the dynamic as the decisions are announced. I mean, certainly I was in the courtroom purely by accident because I was there for another oral argument the day that the court announced its decision in a case involving affirmative action at universities in Michigan. And this was a case in which Justice Sotomayor read her dissent from the bench. And it was really sort of
unusual.
Blistering and unusual. And the dynamic in the courtroom was extremely uncomfortable. And so that's something that's interesting to be there for. But, other reporters like to be in, and this is also a decision that probably your editors are going to weigh in on, like to be in the press room where you can hear them announcing the opinions, but you get a hard copy of the opinion itself as soon as the Chief Justice says Justice Breyer has the opinion, and you can start looking at it and start working on your story. And so sometimes, for example, in the Affordable Care Act case where the individual mandate, the Chief Justice had a very long statement announcing the decision, and so it was some time if you were sitting in the courtroom before you got to the, to the bottom line that the individual mandate had been upheld. Sometimes you can get to that point much faster yourself if you are in the press room with a copy of the opinion. So that actually brings us to our next step, which is to be prepared. You want to make sure that you are in the press room or in the courtroom, that you have everything you need, that you cross your I's and dot your T's. So you need or the other way around, exactly. Cross your T's and dot your I's. You want to make, first things first is you need a credential to cover you certainly could stand in line if you wanted, but you could often have to stand in line for a really long time and no guarantee of a seat. The Supreme Court has two different kinds of credentials. One is what's known as a hard pass for reporters who cover the Supreme Court on a regular basis, and then they can show up whenever the court is in session and cover oral arguments. The other is what's known as a day pass, which is what most people who don't cover the court on a regular basis are going to have. You request seats at a particular oral argument in advance, and then you get to show up that day. It's a one ticket only. Those seats, these are generally the days when most people who do not normally cover the court are coming to the court, are days when lots of other people who don't normally cover the court are coming to the court. So it's going to be crowded. You may well be sitting in a seat from which you cannot see some or all of the justices, and so that at that point it becomes important to know who's talking, even if you can't see them. Sometimes the press office will actually hold up a sign. Justice Kennedy is speaking, Justice Ginsburg is speaking.
That's so helpful.
It is very helpful. When I have been there on a day pass, they did back in 1998. They didn't do that, but they do that now. You don't want to count on them doing that or being able to see it, and so you can listen to audio on the Supreme Court's website or on our website and try to familiarize yourself with their voices. Because it can be hard to figure out who's speaking.
So that's a great tip. If I'm in Des Moines and I know there's a case that my newspaper's interested in, I go online or I call the court, I request this day pass in advance, I fly into DC, but before I get there, I listen to enough audio so that I recognize the voices of the justices.
Yes. And if you're in Des Moines and you can't make it to the oral argument, you have sort of a two-part solution. The Supreme Court will post transcripts of oral arguments at roughly 1 o'clock in the afternoon, the day of the oral argument. Unfortunately, they don't post the audio until Friday of the week in which the cases were argued. This is pretty consistently something that they've been doing for the last few years. There was a time, I think healthcare was one of those cases, when they would actually release the audio within a couple of hours of the oral argument, but they have not been doing that in more recent years. And so you really, if you're not in Washington, you have to write your story off of the transcripts. And if you're in Washington and you're able to go to the Supreme Court, it just depends on how quickly your editors want you to file your story. Right. You may well be having to file at least a first cut at it before the transcripts are available online. The Supreme Court Press Corps is usually pretty cooperative in, sort of working collaboratively to try and make sure that everybody knows what everybody else. If you have a question about what someone has said and the transcript's not released yet, people are usually pretty good about that. I know that in the hour or so after the Citizens United protest this week, everyone was like trying to work together to make sure that we knew how many protesters there were and what was said. You also want to know this case. And in some ways, the Supreme Court, as I said, is very inaccessible in the sense that it's not televised. We don't know what happens at their private conferences. But in some ways, it's very accessible in the sense that everything that the justices have before them when they go to the oral argument is available online. The petitions for certiorari, the parties' briefs, the amicus briefs, and you can't talk to the justices. Most of the parties, except for the United States, will often be very happy to talk to you, though, if it's a complicated case, to explain exactly what's going on, to tell you a little bit more about what's at stake in this case beyond the specific case. And then you can also sort of broaden your investigation, your research to the friends of the court, the amicus briefs, because they're happy to talk to you about what's at stake for their clients, what the big picture is. The United States, as I said, will not talk to you, but it's often an excellent source. If I'm reading about a case and they filed an amicus brief, it's usually the first brief I read. They feel like they have a responsibility to the court to be very straightforward. And so it's usually a very well-written and concise summary of what's going on in the case and what's at stake. They never try to hide the ball.
Right.
Yeah.
So this all goes to knowing the case and knowing the background.
Right, yes. And knowing
Right,
that the background is just as important in many ways. I mean, the court has been around for over 200 years now. They rarely decide a case in a vacuum. There's almost always some case, sometimes not that long ago, that is going to be very important to their decision. The primary exception to this rule that I'm thinking about, the recess appointments case last term, the court had never interpreted the recess appointments clause before, but that's really the exception to the rule. And so you want to look at some of the major cases that are cited in the parties' briefs, because they're almost certainly going to come up in oral argument. The court's going to say, well, what about this case? And how does this conflict, or how would this be your argument be consistent with our decision in this case 10 years ago? And if it's a recent case, you can often go back and not just look at the opinions, but listen to the oral arguments, particularly if there are justices. The Oyez project has many of the oral arguments audio online and easily accessible.
Can you spell that for
Oyez, yes, O-Y-E-Z.
O-Y-E-Z.
Yes, and so you can go back and listen to oral arguments, and it's often good if some of the justices who were on the court then are still on the court, to get a sense of what particular justices are thinking. And that's particularly important. We think of the Supreme Court as this sort of mortal combat with the conservative justices on one side and the liberal justices on the other, and Justice Anthony Kennedy sort of in the middle, but it doesn't always play out that way. And one of the examples I'm thinking of is Justice Antonin Scalia, who we think of as a pretty hardcore conservative most of the time. But and you certainly think of him as being, much more likely to favor the government than the defendant in criminal cases. But he's been at the forefront of a line of cases, for example, involving the confrontation clause. You're right, if you're on trial, to have your accuser be present in court to testify against you. And what exactly does that mean? If the witness is dead, if you're talking about a medical examiner's report. And Justice Scalia believes in the original text of the Constitution. And as far as he is concerned, it says, you have a right to confront your accuser, period, case closed. And so he's actually written several of those decisions in favor of the defendants. And so you don't always want it. It's often useful to go in with a sort of liberal conservative if it's a high-profile case, but it doesn't always get you there.
Right. Good to know.
So, and then the last tip is just to know the big picture. What are the implications of this case going forward? And as I said, you can get amicus briefs. Will often help to fill in that picture, because the parties will, of course, tell you either that this is going to be a catastrophe if they lose, or sometimes they'll, particularly if it's a criminal case or something like that, they want the court to think that it actually will have a very small impact, so that if the court rules for me in this criminal case, there aren't going to be thousands of criminals coming back and trying to overturn their sentences or something like that. And so, you need to find out who's right. What is the actual impact of this case going to be? You also want to look carefully not just at the majority decisions, if there's more than one opinion in a particular case, but at the concurring opinions and dissents, because they'll often tell you a little bit more about what the actual scope of this decision is going to be. A couple of years ago in United States versus Windsor, that's when the Supreme Court struck down the provision of the Defense of Marriage Act that defined marriage for federal law as a union between a man and a woman. And Justice Scalia wrote a bitter dissent saying, well, we are basically now on the glide path to same-sex marriage. Here we are, 2 years later.
Here we are. So. Amy, thank you so much. Amy Howe of SCOTUSblog, we really appreciate your being here. And for all of you, we hope you will go to our website and find the schedule of upcoming webinars. That's nationalpress.org. You can sign up for our newsletter, use the donate button on the homepage, and thank you for joining us in the Evelyn Y. Davis studios at the National Press Foundation, where we are making good journalists better.